members in particular, we pour into them career development, networking, and perhaps above all, conferences. Later this month, we'll be heading down to Austin, Texas for the Texas Chapters Conference, and opportunities like this are a phenomenal experience to meet with conservative thought leaders and shot callers. And by the way,
Shot callers, I like that. That's cool.
just like Judge Boasberg. And
He's a plain Turner.
and when you go to these conferences, you'll see this is really where the magic happens. And be it at the National Conference in Phoenix in March or in Austin here for Texas Chapters, we're thrilled to have you. Now, speaking of being thrilled to have you, if you would like to scan this QR code, you can join our SMU 360 page, and you can follow up with all sorts of details about the conferences and other events. On top of that, I'm going to go back to the previous QR code, and we'd like all of you to register here so we can report to nationals what great attendance we had and get all kinds of funding for all kinds of great Chick-fil-A for more events down the road. Now, for everyone who does register, we will also be holding a raffle, and these lovely objects of interest are up for the taking. So please make sure to register on both of these QR codes. Without further ado, I'd like to introduce our excellent speakers, or at least one excellent speaker for their report.
Plus one.
Professor Josh Blackman. He is a prolific analyst of all things affecting our nation's highest court. He's the author of several prominent books and hundreds of blog posts and law review articles that have each been cited thousands of times. He's also the senior editor of the Heritage Guide to the Constitution. That revised edition will be coming out in October. I highly suggest that everyone obtain a copy. Next is Stephen Hammer, possibly the most accomplished associate attorney at any law firm in America.
That is true, actually. That is true.
Mr. Hammer, we are very grateful to add, is the vice president of the Dallas Lawyers Chapter of the Federalist Society. He's also a Rhodes Scholar, was awarded the Bronze Star by the U.S. Army, is the proud father of 8 children. Most relevantly for our purposes today, Mr. Hammer also clerked for Chief Justice John Roberts, and just this past March, presented oral arguments at the nation's highest court. With that being said, please welcome our excellent speakers.
Thank you, Ethan, and thank you so much, everyone, for being here today. This is an amazing turnout, and I'm glad you're all so excited to hear about the Supreme Court. It was another banner year at the Supreme Court. Now, in fairness, the Supreme Court has a trend of issuing fewer and fewer decisions every year, but those that it does issue, on the merits docket at least, keep us engaged, keep us interested, and there's a lot to talk about. So I'm going to talk about a handful of the most significant cases this term, and then hand it over to Professor Blackman to talk about a few more.
Shake things up.
Okay, so we're going to start off right with the bang, and we're going to get into one of the biggest decisions of the year. The court here took up an issue that had been broiling the lower courts for years, the legality of so-called universal or nationwide injunctions, which the Supreme Court resolved this term in a case called Trump versus Casa. So let me set the stage a little bit here. Since time immemorial, courts had granted injunctions prohibiting the enforcement of a law against the plaintiffs in a case. But in recent years, federal district courts have begun doing something different, asserting a different power. The power to prohibit the government from enforcing a law against anyone, regardless of whether or not they were plaintiffs to the case. Hence the universal nature of this injunctive relief. So the question of whether district courts are allowed to enter these types of injunctions has taken on greater significance in recent years because since the time of George W. Bush or thereabout, essentially every major national policy, as soon as the president has issued an executive order, for example, has come under immediate attack and been enjoined on a universal basis by one district court or another somewhere in the country. And that has several effects on our national policy. First, it freezes policymaking immediately, kind of at the beginning of a presidential term. You know, a president will enter an executive order, whether from either party, it'll get frozen by a district court on a universal basis, so it can't be applied by the government to anyone, anywhere in the country. And then that will take years to be litigated and finally resolved, which kind of coincides with the end of the presidential administration. So it's very difficult for our politics to react to what's going on the ground. And the second major consequence of these universal injunctions is that it really ratcheted up pressure on the Supreme Court to get involved in cases early and often. So the way the Supreme Court likes to resolve cases is to allow issues to percolate in the lower courts, which means district courts weigh in around the country, the courts of appeals evaluate the questions, and then the Supreme Court gets involved when it has the benefit of lots of opinions by lots of jurists around the country. But when you have universal injunctions being issued, it means the Supreme Court needs to get involved very quickly on an emergency basis without lots of further development below. And that has put a lot of pressure on the Supreme Court. Universal injunctions also have an asymmetric effect on the government. So If you are someone who wants to challenge a policy on a universal basis, all you need to do is to prevail before one of the 677 district court judges before the country. You can get it blocked as to everyone everywhere in the country. And if you lose before one judge, then someone else can just take the challenge to a different judge and seek universal relief there. For the government to have to keep the policy in place, however, it needs to win in every venue where that policy is challenged. So it's a little bit of a heads I win, tails you lose that goes in disfavor of the government. In this case, that the Trump versus Casa case is a classic example of universal injunctions in action. So these cases arise from President Trump's executive order involving birthright citizenship. And that executive order provided that the government would not issue citizenship documents for children whose parents were not legally present in the United States at the time the children were born or were here only temporarily. Now, several plaintiffs bring challenges to this executive order in district courts across the country, and they seek universal relief. Meaning, again, they don't want the executive order just blocked as to them and their children. They want it blocked as to the enforcement of it against anyone, anywhere in the country, even if they're not plaintiffs in the case. And these three district courts grant that universal relief. So they block the executive order from being enforced as to anyone, anywhere in the country. The courts of appeals deny stays. And the Trump administration then seeks review in the Supreme Court. And what they say, importantly, is we don't want you, Supreme Court, to weigh in on the constitutionality of the executive order yet. We're not asking you to review the lower court's decisions that this was likely unconstitutional. We just want you to review the remedial decision, the decision to grant this universal form of relief. And so the Supreme Court hears the case and is going to resolve only that remedial issue. In the opinion it's written by Justice Barrett for the 6 conservatives, the court holds that universal injunctive relief exceeds the equitable authority of district courts. So they're not allowed to do this anymore. And this is a decision that's issued on the last day of the term. And if you follow the Supreme Court, you'll find out that the Supreme Court issues its kind of biggest, most significant decisions at the end of the term and often on the last day. And for this type of decision on an issue of great political significance, you might be expecting a lot of fireworks in the opinions, and you will find some fireworks here. But for the most part, what Justice Barrett delivers in this opinion is really a scholarly disquisition on the state of equity at the founding. I consider this textualism done at a very high level. The court says this really comes down, whether district courts can do this or not, really comes down to the scope of equitable authority that Congress gave to district courts in the 1789 Judiciary Act. So Justice Barrett is going to put on her historian's hat. She's going to go back to the time of the founding, and she's going to say, what did courts at equity do at the time of the founding and immediately before the founding in English courts? That's what that's the power Congress meant to give to federal district courts in this statute that kind of gave them this authority, the authority to enter injunctions in the first place. She combs through the historical records and she concludes, no, there is no practice analogous to universal injunctions at the time of the founding or immediately before it. Instead, at that time, suits in equity were brought by and against individual parties, so injunctions ran in favor of individual plaintiffs and against individual defendants. And these universal injunctions that we experience now really didn't come about until the middle of the 20th century, and then really didn't take off until the 21st century in the administration of George W. Bush. So this is really a novelty that can't be supported by history. And therefore, because these universal injunctions exceed that scope of equitable authority that was granted by statute, district courts simply lack the authority to enter injunctive relief on this basis. And again, the court does not pass on the constitutionality of the executive order itself. Justice Sotomayor dissents, and she's joined by Justices Kagan and Jackson. And her dissent focuses on what Justice Barrett calls conventional legal terrain. Essentially, she's going to debate with Justice Barrett the history here, what the equitable power entailed at the time of the founding, and whether this universal injunction practice is in fact analogous to things that were done at the time of the founding. So she says, this is Justice Sotomayor says, the scope of equitable power has always been flexible. The point of equity is to give these flexible remedies. And in fact, courts at the time of the founding were using something called the Bill of Peace, which had this effect of granting universal relief. Justice Barrett says, no, there were certain guardrails on the Bill of Peace that make it non-analogous. In fact, it's more like a class action, which is a separate device that's available today, but has certain protections and limitations on when it can be granted. So she doesn't accept it as an analogy, but that's kind of the scope of the debate is, what does the history here actually tell us? Then Justice Jackson also issues a solo dissent, so she dissents by herself. And for those of you who are starting to follow the Supreme Court, what I'd always recommend is pay a lot of attention when justices write separately and they're not joined by anybody else. Because when you write separately as a justice, you have a lot more freedom to express yourself and the views that you hold really strongly. You have to feel strongly to go out on a limb and to write by yourself. And you're also not constrained by the need to get other justices to join your opinion. So these tend to be very reflective of the justice's individual and personal views. And her dissent is a bit more rhetorically charged than Justice Sotomayor's. She says, simply stated, what it means to have a system of government that is bounded by law is that everyone is constrained by the law, no exceptions. And for that to actually happen, courts must have the power to order everyone, including the executive, to follow the law, full stop. So she's saying if courts don't have this universal injunctive capacity to just tell the government, stop violating the law, regardless of who was the plaintiff who brought this case, it's going to be detrimental to the rule of law. Justice Barrett responds, she calls Justice Jackson's dissent a startling line of attack that is tethered neither to conventional legal sources nor, frankly, to any doctrine whatsoever. And she says, we will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary.
Ouch.
Okay. So strong words from Justice Barrett here. And those are the fireworks that I mentioned. But I think if you look a little bit past that, what we really see in Justice Barrett's and Justice Jackson's opinions are kind of textbook examples of the dueling approaches to federal court jurisprudence that you can really trace back in American history to the time of Marbury versus Madison. So as you start to study constitutional law, you're going to see these two trends and different justices in both of these camps. So one camp, and this would be Justice Jackson camp, thinks that the chief role of federal courts is to be the law declarer, with broad authority to enforce legality and vindicate the rule of law across the political spectrum. Another view, and this is represented by Justice Barrett, views federal courts more as dispute resolvers. Yes, they can say what the law is, as Marbury versus Madison said the judicial role was, but they do so incidentally to resolving concrete disputes between individual plaintiffs and individual defendants. And if they go outside that bound, they're transgressing the limitations on the judicial role. So this debate has really gone on throughout American history. It's going to continue to go on, but I think that's the right way to see these different opinions here. Another observation here is I think this was really a breakout case for Justice Barrett. This is probably, I think, the most significant opinion that she's written while she's been on the court. This is an issue that's really divided lower courts and scholars. It's of great national significance. And I think the opinion is very reflective of her strengths as a justice. It's a very nuanced treatment of the history. This is a difficult issue, but it's very clearly written, very methodical, easy to follow. So I commend it to you for your study. But at the same time, it's easy to overstate the effect of this opinion, and it's somewhat unclear how much it will actually change the facts on the ground. So the court doesn't resolve whether kind of the same relief can functionally be granted through class actions. And in point of fact, after this case goes back down, several district courts have now granted effectively the same relief through the class action device. And that is going to be tested in the lower courts, whether that is a kind of a workaround to this, a way of granting universal injunctive relief if you satisfy the class action constraints. But depending on how that gets resolved, this might or might not turn out to be a very significant decision. So keep an eye on that. The next case I'd like to talk about involves one of the court's forays into the culture war issues. This is United States versus Scrimetti, which involved Tennessee's ban on sex transition treatments for minors. So to set the background here, in recent years, the number of minors requesting sex transition treatments has increased, which has given rise to a national debate over the risks and benefits of those treatments. In the last 3 years, more than 20 states have enacted laws banning sex transition treatments for minors. And in 2023, Tennessee joined those states by adopting a law called SB 1, which banned the use of puberty blockers and hormones for sex transitions on minors. 3 children and their parents challenged this statute. They asserted that it violated the Equal Protection Clause of the 14th Amendment, and the United States then, under the Biden administration, intervened in support of the challengers. The district court where they brought the challenge partially blocked the law, holding that the statute discriminated on the basis of sex and transgender status. It was therefore subject to what's called heightened scrutiny and was unlikely to satisfy it. That got appealed to the Sixth Circuit, which in a decision written by my old boss, Chief Judge Sutton, held that the statute does not discriminate on the basis of sex, that transgender individuals are not a suspect class. The Sixth Circuit therefore applied only rational basis review, held that the statute satisfied it, and it was therefore constitutional. The issue goes to the Supreme Court, which affirmed the Sixth Circuit in an opinion written by Chief Justice Roberts for the 6 conservatives. So to understand the doctrinal moves here, we have to go back to Common Law 101 for just a second. This is a 14th Amendment case, an equal protection case, and the Equal Protection Clause says no state shall deny to any person within its jurisdiction the equal protection of the laws. But it turns out that most laws classify in one way or another. The law that says you can't get a driver's license until you're 16 is a classification based on age, but we don't really have a problem. We don't think that's unconstitutional. And not all laws that classify can be unconstitutional. So what the Supreme Court has come up with is what it calls a tiers of scrutiny approach to review these equal protection claims. Most laws, like the age for a driver's license law, they pass constitutional muster as long as they are rationally related to a legitimate end, and that's called rational basis review. It's a light touch review by the courts when we're not particularly concerned about the type of classification. But certain other types of classifications, they get heightened review. It's more difficult for them to survive constitutional scrutiny. So one example is laws that classify based on race. Laws that classify based on race get strict scrutiny. The government needs to show that it has a compelling interest in the classification and that the classification is narrowly tailored or essentially essential to upholding that government interest. Laws that classify based on sex get somewhere in between that strict scrutiny and rational basis. It's called intermediate scrutiny, and that requires the state to show that the classification serves important government interests and is substantially related to the achievement of those interests. So the question in the case is, what tier of scrutiny applies to this SB1 statute? Is it going to be rational basis, a thing that applies to most medical treatments and that most things survive, or some heightened form of scrutiny? And the Supreme Court says it's just going to be rational basis. It is not going to be a heightened form of scrutiny here. Why does it say that? It says this statute, SB1, does not classify on any basis that warrants heightened review. It classifies on the basis of age because it only applies to minors. And it classifies on the basis of medical treatment because it allows, for example, hormones for some medical diagnoses, but not for others. But the court says both of those classifications are only subject to rational basis review. The court rejects the argument, which the plaintiffs have made, that the statute classified on the basis of sex. And the court says, no, this applies to minors evenly across the board, regardless of what sex they have. So there's no classification on the basis of sex here. Plaintiffs, in addition to arguing that it was classification on the basis of sex, also argue that it was a classification on the basis of transgender status and that that should warrant heightened review as well. The court here makes an interesting and important move, and it avoids answering in the first place whether classification on the basis of transgender status requires heightened scrutiny. The court says we don't need to resolve that question because the statute does not classify on the basis of transgender status. And in making this move, the court relies on a 1974 case called Geduldig, which had held that an insurance program that excluded from coverage certain disabilities related to pregnancy did not discriminate on the basis of sex. And the way the court reasoned there was essentially that some women will be pregnant and therefore they will be subject to this limitation on disability, a limitation on coverage, and some women will not be, and therefore we won't be subject to this limitation. And therefore, because the women will be on both sides of it, it's not a classification on the basis of sex. Now, suffice it to say that Geduldig came in for heavy criticism in the 1970s. It has been criticized heavily since then, and the dissent is going to heavily criticize the majority for relying on it here. But nonetheless, that's the move that the majority makes. It says this statute is like the limitation in Geduldig because some transgender individuals will seek the prohibited treatments, others will not. Therefore, it is not a classification on the basis of transgender status. The court here also rejects the argument that its decision a few years ago in a case called Bostock versus Clayton County controlled the outcome. Bostock versus Clayton County was decided in 2020. It was a very important decision in the employment discrimination context under a statute called Title VII. And this statute, Title VII, prohibits discrimination in employment because of a person's sex. And the question in Bostock was whether that included firing an employee for being gay or transgender. And the court said, yes, it did. Because when you do that, the employer is penalizing the member of one sex for a trait or action, for example, sexual orientation, that it would tolerate in the member of the other sex. And that's the argument the plaintiffs made. It's the same thing here. But the court here says, no, Bostock is distinguishable because the statute's operation here doesn't turn on sex, but it turns on medical condition. So a biological female under Tennessee statute can't get hormones to treat gender dysphoria, and a biological male also can't get hormones to treat gender dysphoria. Therefore, treatment across sexes is the same, and Bostock doesn't apply. The bottom line is that the court ends up applying only rational basis review, and it finds that SB1 satisfies it. It finds that there's an ongoing debate about the risks and benefits of using these treatments. It talks about a lot of European countries where some of the debate has evolved in this in recent years. And it says that states are entitled to weigh those competing considerations for themselves and decide how they want to regulate in this area. Justice Sotomayor, she dissents. She's joined by Justice Jackson in full and Justice Kagan in part. And for her, this case was an easy question. She says SB1, this Tennessee statute, obviously discriminates on the basis of sex. And she uses a hypothetical to illustrate this. She says, imagine a mother who calls a Tennessee doctor, and she's concerned that her child has begun growing unwanted facial hair. What the doctor can do next depends on that child's sex. If the child is a biological female, then SB1 allows the treatment. But if the child is a biological male, then SB1 doesn't allow the treatment. And so what you see, you flip the sex, you get the opposite outcome. To Justice Sotomayor, this is just like Bostock, same situation. But the court's response here is that no, that doesn't work because the medical treatments that would be sought in those cases are different. A treatment for hirsutism, which is excessive hair growth, is entirely different than a treatment for gender dysphoria. A couple observations about this case. I think one thing we can say is that the court seems to have come a long way since Bostock in 2020. It's notable here that Justice Gorsuch, who was the author of Bostock, doesn't write separately and said very little at argument.
Zero.
Okay.
Not a word.
Yeah, check the transcripts. So what accounts for that? It's unclear. It could be that that was a Title VII case, a statutory case. Here we have the Equal Protection Clause in a constitutional case. It could be broader considerations than that, but what's notable here is that the court is going to be more flexible in allowing this than it was in Bostock. And another observation on this is that although this case was really heralded as a major culture war win for conservatives, I think it's actually quite a modest decision. And in that, it really reminds me of Dobbs. All the court is saying here is that states have the ability to make this decision for themselves. It's not saying what decision they have to make. It's not taking this option off the table. It's saying that we as the court are not going to resolve this question based on the Constitution. The ball is in the court of democratic representatives and the people through those representatives. And that's all the court is going to say about it. That brings us to the third case I'm going to talk about today. And it's
His case.
Okay, there you go. Well, it's yes, this is a case that I had the privilege of arguing. It's a case called Riley versus Bondi. This case is probably not the one that you came to a Supreme Court roundup to hear about, but you're here anyway. So I figured I'd share a little bit about the experience of getting to argue this one. This case involves a complex question of immigration law and the timing of judicial review. So the Immigration and Nationality Act, which is the biggest statute that governs our immigration system, it sets out certain expedited removal procedures for certain classes of aliens whose deportation Congress wanted to speed up. And in this case, it involved an alien who was convicted of an aggravated felony. So most aliens, when they're going to be removed from the country, they get to go before an immigration judge and have a hearing, then kind of an in-person hearing. They then get to appeal that within the agency to something called the Board of Immigration Appeals. So they get a lot of process before they're ordered removed from the country. But in the case of an aggravated felon, they don't get that process. They have essentially a DHS uniformed officer hands them a piece of paper that says, you are an aggravated felon, you've been ordered removed from the country. And they can't challenge that anymore inside the agency. The only thing that they can do is they can seek a country-specific form of relief called withholding of removal. And withholding of removal, it's a very interesting form of relief. What it means is essentially you can say, look, I can't challenge within inside the agency that I'm going to be removed from the country, but don't remove me to country X. And in this case, it's going to be Jamaica. Don't remove me to Jamaica because if you remove me to Jamaica, I'm likely to be tortured or persecuted by the government. And the United States has signed a treaty saying it's not going to remove people to countries where they're likely to be persecuted or tortured by the government. And so they can seek withholding of relief. Now, if they get withholding of relief and they win at the end of the day, they can still be removed to any country in the world. And you probably heard in the news about people being removed to countries with which they have no relationship, like South Sudan or other places like that. That's called a third country removal. And if you're subject to a removal order, and even if you win this withholding relief, you can still be removed anywhere in the world because that's what the statute says. So the question in this case is the relationship between these two things, this order of removal that you get kind of on day one that can't be challenged inside the agency, and this order denying withholding relief, which might take a year or more for the agency to process. Now, the key here is that the statute says an alien can get judicial review of this withholding relief, but in order to do it, you need to file a petition for review within 30 days of a, quote, final order of removal. And the question is, what is the final order of removal? Is it this order of removal that can't be challenged? Sounds final. Or, that's going to be my position, or is it going to be this withholding relief, which can't affect the removal order in any way? Okay. So you know where my position is going to be on this one. The case involves a man named Pierre Riley. He came to the United States and Jamaica in 1995 on a 6-month tourist visa, and he is still in the United States 30 years later. So he overstays his visa. He ends up committing several felonies. He's involved in a drug trafficking conspiracy with firearms. He goes to prison for 20 years or 15 years. When he gets out, he's an aggravated felon, and so he's subject to these expedited removal proceedings. He gets his removal order, and then he says, I want to seek withholding relief as to Jamaica because I'm afraid I'm going to be tortured or persecuted if I get sent there. The agency, it takes about a year. The agency rejects his withholding claim, says it's speculative. You don't have a good basis for saying you're going to be persecuted or tortured there. And then he wants to go to the Court of Appeals. So you get judicial review straight into the Court of Appeals. And he wants to get judicial review of that withholding decision. He files his petition for review, but the Fourth Circuit says, we can't hear the case. We don't have jurisdiction to hear the case because you didn't file within 30 days of your order of removal, the one that happened like a year ago. You needed to file then, and because this deadline is what we call jurisdictional, we can't hear the case. We lack the power to do it. So he goes up to the Supreme Court and he says, I want you to resolve two questions that have divided the lower courts. One, what's the trigger for this 30 days? Is it that first piece of paper, or is it the end of the withholding proceedings? And second, is this deadline jurisdictional, or what's called a claim processing rule, which can be waived or kind of set aside by the other side here, the government? So interestingly, the government says, you know what, Mr. Riley, you're right. The lower court got it wrong. The trigger is that first thing, or the trigger is the second thing. So it was timely, your petition for review was timely, and the deadline's not jurisdictional. So the government, both sides are agreeing with each other here at the Supreme Court. And what happens in this situation is the Supreme Court appoints an amicus curiae to defend the judgment below, to explain why the court below got it right. And it does this so that it can hear both sides of the issue before resolving this question that's divided the courts of appeals. And so that was how I got involved in the case. The court asked me to come in to support the judgment below, to write a full brief, and to argue at the Supreme Court in defense of this position.
Unpaid, right?
Unpaid. Okay.
Yeah.
So this is a little bit of a good news, bad news situation, and not just because it's unpaid. The good news, bad news is the court is like, hey, we'd like you to argue at the Supreme Court. And you're like, that's amazing. This is going to be fantastic. Here's the bad news. The position is so bad that both sides agree that it's wrong. Even the side that won below agree that it's wrong. So good luck defending this. And what you see in most of these cases is kind of what you'd expect. They usually don't go very well because that's the reason why the party that won below doesn't feel comfortable defending it. So we knew we were going to face a kind of difficult challenge here. You get into the case, we develop the arguments. It's a really fun experience when you're a court-appointed amicus because you have no client.
Mm-hmm.
Your only client is the judgment below, which is a very accommodating client. You don't get a lot of pushback from the judgment below. No one is reviewing your brief. So you have the kind of freedom to develop what you see as the strongest arguments. And of course, the court is really trusting you to kind of present in candor what the strongest and weakest arguments are because they know that you're not having to accommodate to client concerns in the case. So again, there were two issues in the case. The first one is this, what triggers the deadline? And on that one, I had a strong textual argument based on the meaning of the final order of removal under the statute, as well as two of the Supreme Court's precedents that had said that these withholding proceedings don't disturb or affect the validity of the removal order. So I had a strong position on both text and precedent. And the challenge in the case was kind of explaining the practicalities, because even as I probably explained the case to you, you're saying, well, he wants to challenge this second order. Why would he have to file this petition after the first order? And so it's kind of a case of, well, there's a formal answer why, because the text and precedent requires it. But does this mean that he's not going to have the ability practically to actually challenge the second order? Or if so, how is he going to do it? And what's the administrative burden going to look like? So we knew we needed to address that in the briefing. We knew we needed to be prepared to address that at argument. And that was a lot of what I focused on in the argument preparation. The second question was, is this deadline jurisdictional or a non-jurisdictional claim processing rule? That's something if you follow the Supreme Court, you'll see there's several of those cases come up every year. And the answer in 99.9% of cases is that it is non-jurisdictional. And so we knew we had an uphill battle there as well. I had a great experience kind of preparing for argument. I had 4 moot courts in DC. I had the feedback of a wonderful team at Gibson Dunn and a lot of people supporting me and preparing for this, which was my first Supreme Court argument. And argument itself was really an amazing experience. I mean, if you stand there in the well of the Supreme Court, the justices are basically like this first row right here. That's how far you are from the justices. And just like this bench here, it kind of curves around you. So you find yourself, it really feels like the justices are surrounding you. And it's very conversational, which it sounds a little intimidating, but it's actually kind of comforting because everything else kind of closes out. You just focus on this conversation with the individual justices. Ultimately, the opinion comes down, and it's an opinion written by Justice Alito and joined by the Chief Justice and Justices Thomas, Kavanaugh, and Barrett. And they hold that the deadline is triggered by that first thing. They agree with me that it's triggered by the final administrative removal order, this piece of paper that you get at the beginning of the process, and not the withholding decision that comes at the end of the process. So it's 5-4 on that question. The justices agree that the statutory text and the court's precedents require that, and they say kind of the administrative complexity that's going to be created here can't overcome the text and the precedent. And on the second question about whether it's jurisdictional or not, they disagree with me 9-0. So kind of, you can't win them all. Justice Sotomayor dissents. She's joined by Justices Kagan, Gorsuch, and Jackson. And this is how she sums up the case. Should Mr. Riley have appealed the board's order denying deferral of removal before the board issued it? The answer ought to be easy. Yet the majority today renders the statute incoherent, holding that Riley should have appealed the order 1 year and 3 months before the board entered it. Well, when you put it that way, Justice Sotomayor, it doesn't sound great, does it? She also says, today's decision is the rare holding that benefits no one. Well, not no one. We were pretty excited about it at our house. Okay, so observation here. This is one of the workaday, in the weeds Supreme Court cases that don't get the headlines, and understandably so. But throughout this entire process, extremely grateful to be involved in this process at all. And I was just very encouraged by the amount of time, the attention, the detail that all sides put into this case, into this really complex question of immigration law, and just kind of trying to get it right. There are so many people involved in this. And, in a case like this, just trying to get into the weeds and get these really difficult questions right. It was encouraging for me as an American, encouraging for me as a lawyer, and it was a real privilege to play a small part in that.
My turn?
Over to you, Professor.
Thank you. Thank you. Thank you. So I was planning to talk about some cases from last term. Ghost guns, TikTok, internet porn. I'm calling it audible. So completely new topic, sorry. Let's talk about the lower courts. So you learn in civil procedure that we have inferior courts and we have a Supreme Court. And usually the way it works is the Supreme Court tells the lower courts what to do. But we're witnessing something that's a bit unusual. It's what I call a lower court revolt. I think we're seeing lower court judges think the Supreme Court's getting things wrong. And they're finding ways to distinguish and perhaps even evade Supreme Court opinions. And remarkably, they are pushing back on the Supreme Court. Just this morning, as I was riding to school, which is why I changed the topic, a dozen judges talked to the press, all anonymous, of course. They have life tenure, they don't need to be anonymous, but they're talking to the press. And they're complaining about the court, that the court's issuing these rulings on so-called emergency docket. They're not well-reasoned. And that Chief Justice Roberts, his former boss, is not standing up for judges, doesn't have their back. In fact, the chief, they say, is at fault because by ruling for Trump, they're legitimating the criticisms that Trump has waged against his lower court judges. I think we're moving towards a bit of a crisis, right? The crisis is not Trump ignoring the courts. That's what everyone's worried about. The crisis is in the lower courts. The lower courts no longer trust the Supreme Court. And we're seeing a massive resistance, perhaps not on the scale since the Civil Rights era. But this time it's not judges in Alabama or Mississippi or Texas. It's judges in Boston, Maryland, and San Francisco. So let's start. Since Trump's second term began, federal judges have become basically a de facto council revision, right? Trump can't do anything without a judge saying so. And remarkably, judges are issuing what's called an ex parte temporary restraining order. Okay, what does that mean? Ex parte means outside the parties. As soon as a motion for restraining order is filed, these judges are granting it. And they're granting them so quickly, they can't even read them. In fact, you can time the minutes. If you count the number of pages in these briefs, and you assume how many pages an average person can read in an hour, they are granting orders for even reading the papers. I can be sure of that. And then because there are these TROs, they cannot be appealed. Only through what's called the writ of mandamus can you challenge a temporary restraining order. And these TROs, in fact, for a month. So basically, every federal judge who issues these rulings has basically the say on it for an entire month to handcuff the executive branch. Now, during the last administration, there was a lot talking about, Fort Worth and Wichita Falls and Amarillo, different cities where these conservative judges. Fair enough, forum shopping's rational. Right? If you're the Texas AG, you go to Amarillo, you go to Fort Worth, you go to Wichita Falls, expected. But progressives don't need to do that. They can go to Boston. I have a lot of Boston cases today. In fact, I call it the Boston TRO party, right? We are seeing, or the Boston Massacre. We are seeing judges in Boston effectively take control of the executive branch. And so the Trump administration has just basically one recourse, which is an appeal to the U.S. Supreme Court on its emergency docket. It's called shadow docket. Don't just call it the emergency docket. Just be normal. It's not called the shadow docket. There's nothing in the shadows. It's all transparent. It's open. It's visible. We see what they're doing. Not some sort of secret court. And more often than not, the Supreme Court is saying to lower courts, You guys screwed up. But what's remarkable is you're having courts being reversed in issues twice. Let me give you a couple examples. First, involving immigration. This case called the Department of Homeland Security versus DVD. It's not the movie, it's the guy's initials. It's better than the other person's name was AARP, another guy's initials, and FGM. Ooh, Google that one. This case involves third country removals, which Stephen mentioned earlier. So you have a number of Venezuelan people who they were alleged members of TDA, Trinidad and Tobago. They said, we will send you to South Sudan. Okay. A federal judge in Boston says, no, you can't do that. Again, there's no claims of persecution in South Sudan. It's not like they have any sort of allegations in their home country. And I'm not joking you. The federal officials transporting these individuals to South Sudan were at a stopover in Djibouti. Do you know where Djibouti is? It's in the Horn of Africa. Again, Google it. It's a country. The judge said, you cannot leave Djibouti. This was meant to be a stopover, temporary. They were there for a few weeks with no reinforcements, no aid, and these people who were suspected of being gang members in this foreign country. Okay. So on June 23rd, the dates are important here. On June 23rd, the Supreme Court says, no, you can't order them to stay in Djibouti. Carry on to South Sudan. Okay? That seems like a pretty big rebuke. A few hours later, not the next day, a few hours later, the judge in Boston says, well, that's fine, but my earlier ruling is still in effect. An earlier ruling was not vacated by the Supreme Court, it's still in effect. Stay in Djibouti. Wow. Wow. DOJ files what they call a motion for clarification. If you're ever clerking at a motion for clarification, that means you probably screwed up. A motion for clarification, right? And I'm just going to read from the DOJ filing. It says, the Boston judge's ruling was a, quote, lawless act of defiance that once again disrupts sensitive diplomatic relations and slams the brakes on the executive's power of removal. On July 3rd, about 10 days later, right before 4th of July weekend, the Supreme Court reversed the lower court again. Look, most judges go their entire career without a single case with the Supreme Court. Unless your name is Matt Kaczmarek, right? Most judges go their entire career without a case for the Supreme Court. This judge was reversed twice in the span of 2 weeks. That's some life goals, right? I guess you should admission to the Harvard Club for life, free. Get to Harvard later. Even Justice Kagan felt compelled to speak up. She said, I don't see how a district court can compel a compliance with the order we stayed. Okay. Next, presidential removal power. You'll learn about in con law, does it president the power to remove all officials? Congress has tried to protect or insulate certain officials who are so-called independent agents. I use this scare quotes intentionally. 90 years ago, there was a case called Humphrey's Executor, where the court held that the president cannot fire a member of the Federal Trade Commission without sufficient cause. All right. So Trump comes to office and he basically says, screw this, we're going after Humphreys. And starts firing everyone. He fired more people than I can count. In May, the court decides a case called Wilcox, which basically said, yeah, Trump could fire members of the NLRB and the Merit System Protections Board, the MSPB. Okay? This wasn't a fully reasoned opinion, but it seems pretty clear that this means that Humphrey's executor is dead. And don't believe me, look at Justice Kagan. She said Humphrey's executor is all but dead. But the judge in Maryland didn't quite get the point. Trump fired members of the Consumer Product Safety Commission, which I'd never heard of. I guess they're important. I've never heard of it. The judge says, no, Trump, you can't fire them. And he mentions Wilcox in a footnote. Let me tell you something. If there is on-point Supreme Court authority, you do not put that in a footnote. That is bad practice, but the judge did it. 3 weeks later, the Supreme Court, with Chief Justice Roberts, the majority, said, this case is not different from Wilcox. You are a reverse Maryland judge. Okay? So again, 2 cases where federal judges kind of thumb the nose at the Supreme Court. Case number 3 involves Doge. Right? We all love Doge. If you want to sue the government for breach of damages or breach of contract for damages, there's a special court for you. It's called the Court of Federal Claims. Congratulations. They have a limited jurisdiction under the Tucker Act. Okay? You cannot go to your local federal district court. You have to go to D.C. That's the rule because of sovereign immunity. Yet, amazingly, all these progressive groups decided to file lawsuits again in Boston. What's it with Boston? You live there. I never lived in Boston. They sued in Boston. So again, California sued Department of Education in Boston. Look, I don't think forum shopping is irrational. They said, okay, well, the Ninth Circuit's pretty liberal, but the First Circuit's even more liberal. Let's go there, right? And also Boston's nicer than Amarillo this time of year, I suppose. It's beautiful at the fall, the foliage, right? I keep making fun of Judge Kaczmarek, but he's a good friend. A federal judge in Boston said, yes, you can sue here. Welcome to Boston. We will save you. Okay. The Supreme Court ruled, no, these cases belong in the Court of Federal Claims. This is called Department of Education versus California. Okay, this was pretty straightforward. But then another judge in Boston, it's Boston all over again, said, you know what? I'm going to let you sue the government over funding cuts. This involves DEI grants. The case belongs here. Why? This is Judge Young up in Boston. He says, well, the California decision was, quote, not final. He said the Supreme Court's order was without full presidential force. The judge in Boston agreed with the dissenters in this California case. Wow. If you're writing a brief, unless it's Josh Blackman brief, don't cite Supreme Court dissenters. That's a bad idea because they lost. Okay. Once again, DOJ filed an emergency appeal, and they said we have a lower court free-for-all where judges are elevating their own preferences over those of the executive branch. Okay, a month later, August 21st, about 2 weeks ago, the court reverses a case called NIH versus APHA, the National Institute of Health. The court, 5-4, said cuts to funding belong in the Court of Federal Claims. Damn it, we meant it. Now, in fairness, Chief Justice Roberts, sorry, I'm just pointing at you, kind of dissented. It was a really weird one-paragraph opinion. I think he was just figuring something. He had to put something on paper. This was John Roberts' special. Details, not important. Okay. But what did matter is Justice Gorsuch. He wrote a concurrence with Justice Kavanaugh. And he basically called out the lower court judges. He said, when this court issues a decision, it's a precedent that commands respect. This court's precedents cannot be circumvented. Gorsuch writes, lower court judges may sometimes disagree with the court's decisions, but they're never free to defy them. OMG. Judges are used to criticizing others. They're not used to being criticized. Again, if you want to become a judge, don't do things that are controversial. Unlike Brantley. Sorry, right? Generally, the way to become a judge is to make everyone love you. And, oh, he's such a nice guy. Oh, he's a good guy. Goes to the bar association. That's to become a judge. They're not used to being criticized. They like asking questions. They don't like answering questions. Trust me on this one. They don't. I piss off a lot of judges. I'm okay with that. I serve a role. 2 days ago, Judge Young in Boston, the one who said that the Supreme Court's rulings were not precedential, said, so he kind of apologized, not really. He said, well, I didn't know that these rulings are precedential. I've never been accused of defying the courts. I've been a judge for 50 years. It's a long time, maybe too long. It's 80. That's stuff you can do. Go skiing. I don't know. Right. He said he kind of apologized. And then yesterday, another judge in Boston, I'm telling you, it's Boston, right? There's something weird going on, put in an order, a footnote, and she said that Justice Gorsuch's concurrence was unnecessary and unhelpful. A lower court judge said a Supreme Court's concurrence was unnecessary and unhelpful. Who do you think you are? Oh, I know who she is. She was the judge who decided the Harvard affirmative action case, and she got herself reversed real bad. And she was a judge who just ruled that you can't cut money to Harvard, and she's a judge who ruled that you can't take away student visas from Harvard students. How does the same judge get all three landmark cases at Harvard? How does that happen? Is she in Amarillo? Is she in Fort Worth or Wichita Falls? No, forum shopping. So Massachusetts actually adopted a judicial reassignment policy where all the cases go to Boston. And who do you know gets it but Judge Burroughs? So look, I can go in circles, but I won't. I'll go one more. This morning, my speech is updating itself every time I give it. 12 judges spoke to NBC News, 12 of them, a dozen, and they criticize the Supreme Court. And they say, we need more guidance. It's not fair that you're reversing us with these short opinions. It's not fair. You need to have our backs. But one judge, to his credit, and this apparently is an Obama nominee, we'll see where he sits. It's anonymous. He says, certainly, There's a strong sense in the judiciary among the judges ruling in these cases that the Supreme Court's leaving them out to dry. They're partially right to feel that way they feel. But the judge added, again, this is an Obama point. You don't know who it is. It says, the whole Trump derangement syndrome is a real issue. Yes, my friends, judges have TDS. You know, the federal judiciary healthcare policy should cover TDS, maybe some counseling or something, right? The whole Trump derangement syndrome is a real issue. As a result, judges are mad at what Trump is doing or the manner he's going about things, and they're failing to stay in their lane. That's a key point. Trump's greatest strength is making people overreact, right? Trump does something crazy, and the other does something even more crazy overreact. But there's a difference. Trump's elected president. He's allowed to do crazy stuff. He was put in office. No one used to do crazy stuff. That's why people voted for him, to shake things up. Lifetime judges have no accountability. They're there forever, and they're overreacting. Judges issuing these ex parte TROs, they've been reading briefs. Judges treating Supreme Court opinions as not quite precedential and, carefully distinguishing Supreme Court precedent. No, that's what you do if you're an advocate, not a judge. And if these judges actually, Stephen's going to laugh a minute, if these judges actually think that Chief Justice Roberts has lost control, they might be right. I've been calling Roberts for years to step down. I think he lost the boat a long time ago. I think he's having a revolt within. In any other corporation where there's a revolt, the CEO loses a job. Okay, the CEO has his own job to pick. Maybe LA Justice Kavanaugh is the chief seat. I don't know. He's been speaking out publicly and defending the court. I don't know what the chief's doing. By the way, the chief should resign from the Smithsonian Institution. That one he should. The chief is actually the chancellor of the Smithsonian, and I think Trump's going very close to firing people there. That's not going to work. So historically, the VP was actually the head of the Smithsonian. There's only more recent innovation. I think Roger Taney actually took that power. We should give it back. I think Roger Taney was the first chancellor of the Smithsonian. Before that was a VP, a vice president. Anyway, I digress. We're witnessing a remarkable revolt in the lower courts, and I don't know how this one ends, but I think we need real leadership at the top to help see it through. See, this is why he's the good cop, I'm the bad cop. Thank you all so much. I will never invite it anywhere at the Supreme Court. Thank you. We have time for questions?
We have time for a couple questions.
Yeah, we have about 5 minutes. So
Okay, questions, please. Yes, sir.
How do you think the court chose Trump v. Costa to address the issue of universal injunctions?
It's a great question. It's a question that had come to the court several times, and the court had not reached the question, partially because there were kind of other merits questions in the case that the court resolved before getting to it. Those have resulted in like a number of separate opinions where justices had opined about their views on it, but had never had the need to reach it. I think partially it's because of the way the Trump administration brought it up. So they didn't seek review of the merits question. They only teed it up as to the universal injunction question. And I think that was kind of why it was the only show in town. If you're going to take it, if you're going to get into this case, that was the only thing you were going to do.
The better question, did Trump sign the birthright order to kill nationwide injunctions? In other words, what's the quickest way to get the court to kill nationwide injunctions? Birthright citizenship. In other words, Trump overreacts, everyone else overreacts around him. So that might be the 4D chess. I don't know. We'll find out maybe later. Other questions? Come on. Yes.
Any examples of the administration modifying its own conduct that comport with some of these lower court rulings?
I think they followed all the orders in good faith. I mean, there might have been a couple borderline cases where a judge ordered you to turn around planes in midair over a weekend on Good Friday or whatever it was, and maybe they did not comply within a few moments. I'll stipulate to that. But some of these orders are crazy, right? Some of these orders truly, without giving a chance to even seek an appeal, are impossible to follow with, right?
I think DVD is an example. So that stopover when Djibouti,
They stopped there, yeah.
They held them there
For a couple weeks.
until they got released.
In Djibouti, I don't know where that is. It's on a map. I mean, this is not a place we had American facilities. Right? They didn't have American personnel to help them. They were basically stuck in a foreign country, and it was a bizarre ruling. Yes, in the back.
It's just my second week, so sorry if this is a dumb question, but is there any other way for these lower court justices to be disciplined except for just a snarky comment from a Supreme Court justice?
Well, historically, the way you dealt with recalcitrant lower courts is by reversing them. They got the picture, but now they're speaking up. They're talking to the press. This is why I think the Chief Justice's strategy is not palatable. He likes to. So there was a leak, right? There was actually a leak of a transcript from a judicial conference meeting where some of the lower court judges were telling Roberts that we're really worried about Trump. And Noah Roberts says, well, it's not so bad. He's been nice to me. And, we had a good conversation at the State of the Union address. So again, I think he sort of lost, he's lost the thread. The answer you're thinking about is what's called impeachment. And I don't think, look, in the abstract, if a lower court judge flagrantly disregards a Supreme Court ruling, is that impeachable conduct? I mean, mandamus is a good remedy. You can also reassign them, right? The circuit court can take them off cases. The Supreme Court could do that as well. There's a judge in D.C. named Pauline Newman. They basically put her on permanent leave because she won't take a health exam. There are a limited number of tools you can use. No, I'm not exaggerating. She's 94 years old, but genius, brilliant, sharp. And they've taken her off all cases because they wanted to take a brain exam, and she won't do it. It's a scandal.
I think the Trump administration actually asked for reassignment in the DVD case, and the Supreme Court didn't do it, but that is one tool in the toolkit, reassigning that case to a different judge who's going to comply with the orders.
There are none in Boston. They're all the same.
Like, how concerned are you about the proliferation of political views being mixed up in a court that's supposed to technically be indifferent? Obviously, we have like conservative versus progressive justices, but I mean, at this point, political influence in the courts is so rampant. Are you concerned about that, or do you think that that's just the natural course of the courts at this point?
I think it's something that should always be resisted, and I think just the nature of the media and the press tends to focus on the most kind of politically divisive, the 6-3 cases. But I think if you kind of look below the surface, you're going to find a high degree of unanimity at the Supreme Court and a high degree of kind of cross-pollination. Like just in the case that I argue, Justice Gorsuch going with the liberals to be in dissent, you find actually a lot of that going on. But that's not what the press tends to focus on. So I think that it would be beneficial for us as like court followers and lawyers focus on the substance instead of kind of the flash.
I mean, like, what percentage of circuit court opinions are unanimous? Like 90-something%?
Yeah.
Almost 90% of the lower court opinions are unanimous. So ideology doesn't matter that much, but it's these high-profile cases which are all being funneled to Boston or Maryland. It's predictable at this point. And I think some of these lower court judges should just take their lumps and move on. You're there for a reason. You're not God. Well, the problem is, sorry, no offense, district court judges think they're gods because no one ever tells them what to do, right? If they get reversed, it's like 3 years later, and then maybe there's like, abuse of discretion standard, they get some legal room, right? It's very rare for have a lower court judge being directly chastised by the Supreme Court and they're flipping out. They're not used to it. They don't like to be criticized. They like to be loved. When a judge walks through, everyone kind of stands up, right? Your Honor, they respect. That's all. It's not good for your ego. Sorry.
Well, fortunately, everyone, we're out of time. If you have any more questions, hold the applause, and then as the great Jeb Bush did, we'll ask you to please clap. We're going to meet out in the hallway if you have any further questions, but first we just want to announce the 2 winners of the raffle.
Ooh, win the raffle.
The first winner is Elliot Wallace.
Woo!
The second one is Brandon Sonier.
Woo! How many people enter the raffle?
Well, thank you, everybody. Let's take her.
Thanks, man.
Yeah. You got plenty of material.
I gotta write something more.